Falmouth versus Civil Service Commission.
All right. Mr. Hadas, is that who's going up first? Have I pronounced it correctly?
Pretty close, Your
Well,
Honor.
why don't-
David Hadas. with the
Hadas,
Civil
fine.
Service
And
Commission.
Mr. Hadas, you have 7.5 minutes.
Thank you, Your Honor. This case hinges on the meaning of the statutory phrase, appeal in writing. But this Court is not being asked to interpret that phrase. Rather, it's being asked to determine whether the Commission was reasonable when it interpreted that language. Courts traditionally afford administrative agencies considerable leeway in promulgating rules and regulations and will not invalidate those rules and regulations unless they cannot be sustained under any conceivable ground. Certainly,
Mr. Hadas, you could just help me right at the beginning. Replete in lots and lots of situations, there's a difference between filing and service, correct?
correct.
Other than this context, do you know of other situations where filing is complete upon dropping it into a mailbox?
All the time. The mailbox rule or the postmark rule
And
is...
for filing as opposed to service?
Oh, absolutely, absolutely. It is prevalent in statutes, it's prevalent in court rules, and it's prevalent in administrative rules such as this. It even exists in the standard adjudicatory rules, which govern almost all administrative proceedings in the Commonwealth.
And filing means some proof that it was deposited in a, in this case, United States mailbox or at the post office, correct?
Correct. And courts
Do
are...
we have the proof in this case, as opposed to the date of the letter?
No, there's the actual postmark is not in the record.
Then how do I know that filing was complete upon mailing?
Well, as the appeals court noted,
I know
the town conceded the point. Now
But the town indicates they didn't concede the point.
in their appellate brief, they did not concede the point, but that's not where the issue was waived. The issue was waived prior to that.
Well, I take it you can back into it by, it was actually received on the 23rd. The deadline for submitting a, quote, appeal in writing, doesn't even use the word file, was the 21st.
Correct.
And therefore, understandably, there would perhaps be a concession. I don't know what days of the week we're talking about, but there was a concession that it had to have been postmarked at the latest by the 21st.
Correct. If the issue was raised at the time, presumably there would have been a finding of, if not the postmark itself, at least circumstantial evidence, as Your Honor indicates, that the letter dated on the 17th was sent that day or soon thereafter. To conclude otherwise would to essentially say that the attorney who sent the letter backdated it by at least 5 days. So the commission would have been within its discretion, even if it had lost the actual postmark.
Well,
to make
why
that
do you
finding.
say that the town conceded that the postmark was before the filing deadline?
Because it didn't argue it. It didn't argue it before the Superior Court in its motion for judgment on the pleadings, which is not in the appendix, but it's in the record. There's no mention of that issue. It's only whether the rule itself is valid.
Do you want to go to the substance?
Yes, please.
If we find that they couldn't do the mailbox rule, then that's the end of that. We don't have to go to the substance, do we? The appeal should have been dismissed.
That is correct, and other than that, I would just ask. In that circumstance, I would ask the court that it apply its ruling prospectively, not retroactively, for the reasons discussed in the brief. No one can really dispute that. Officers.
Everybody thought that if you put it in the mailbox.
Correct. That's how attorneys operate all the time. They follow rules of procedure.
You cite cases, and you did this morning, that you say support the mailbox rule, but don't they primarily involve pro se prisoners?
Correct.
And isn't a pro se prisoner in a very different situation because they can't, A, walk to the courthouse, walk to the mailbox, and they can't control when the prison authorities place their letters in the U.S. mail.
Absolutely. There are equitable considerations in this Court's decision in Hartgrove and the U.S. Supreme Court's decision in Houston that led the courts to read the language in such a way. But the reason we cite those cases is not to equate Officer Deutschman with the situation that a pro se prisoner finds himself in. We cite those cases just to demonstrate that the language is flexible enough to allow that type of interpretation. And the Court's approach in those cases was that, given the equitable circumstances, if the language is flexible enough to allow such an interpretation, then the Court should interpret it in that way.
Mr. Hadass, the language that we have to interpret is the language that says within 10 days after receiving written notice, right?
Correct.
And is it your position that you received the written notice within 10 days?
Only if you have the mailbox rule, right?
Well, I think your reading language, you need to go a little bit further than that. It's within 10 days of when Officer Deutschman received notice of his suspension, he has to, quote unquote, appeal in writing.
Appeal in writing.
So it's not, there's no word delivery or receipt or anything like that.
Well, the statute
Or even
requires the
file.
hearing, though, to start within 10 days of filing. Isn't that right?
That's right.
And if filing equals mailing, which is your position,
Right.
then some or all of the 10 days could have elapsed by the time the Civil Service Commission actually receives the written appeal. And it could be that the 10 days for the time in which the hearing is supposed to start could have totally elapsed by the time the Commission actually receives the mailing, the appeal. Could be.
Theoretically, that's true. As a practical matter, no Civil Service Commission hearing has started within 10 days in decades. It's
Or
just,
another way of looking at it wouldn't be, since what the statute requires you to do within 10 days is to, quote, appeal in writing. That can be, put it in the mailbox. It may be then that the deadline for hearings or other events that refer to filing are triggered by actual receipt. But the person has still put his appeal in writing in process by depositing it in the mail.
yes, and the language of Section 43 supports that, because it says appeal in writing in the first sentence, and then a couple of sentences down it talks about the certain dates being triggered from the filing. It uses different language, so conceivably the Civil Service Commission could say you're timely because the postmark was within 10 days, but...
I would say, and that's the problem with this, that would be extremely misleading to individuals who are not lawyers to say, I can rely on the mailbox rule, but then that doesn't constitute filing, which is why
Well, as a practical matter, what would happen is the Commission would, once it actually receives the papers, would send out notice to the parties that there's a case pending and maybe schedule a pre-hearing, whatever the case may be. And in that notice, it would identify a filing date which someone could argue that certain other dates are triggered under the statute.
But your regulation says that when it's placed, when it's postmarked, that shall be deemed as the date it is filed.
That is the language of the rule. That's correct.
The rule that's in question here.
That's correct.
you will have to rely on your brief for the substantive part. Thank you, Mr. Haddad.
And sister counsel. Thank you.
Ms. McClavey?
Good morning, Your Honors. May it please the Court, my name is Sheila McCravey, and I'm here on behalf of Mark Deutschman, a 25-year veteran of the Falmouth Police Department. The case before you is an administrative appeal from the Civil Service Commission. Officer Deutschman appealed disciplinary sanctions imposed upon him by his employer, the town of Falmouth, after they found him in violation of a number of rules and regulations of the Falmouth Police Department. Some of these violations included unnecessary force, false arrest, conduct unbecoming a police officer. Now, while the appeals court decision did focus on the jurisdictional issue, I will focus on the substantive issues, which the appellant also claims were in violation of, there was a violation of law, and that the commission's modification of the disciplinary sanction was not supported by substantial evidence. Now, the burden was on the town to prove that just cause existed to warrant a disciplinary sanction of 120 days.
Well, they certainly proved just cause to warrant a sanction, and that was certainly confirmed by the Civil Service Commission.
Absolutely, Your Honor.
And in deciding that the sanction should be 60 days suspension versus 180 days, to what extent did the Civil Service Commission focus on the prior record of the officer, which seems to me to be very relevant, but hardly even mentioned in the Civil Service Commission?
Well, from what I can tell from the record, if you look at the facts that were found by the town, in comparison with the facts as found by the commission, it is very clear that the extent of the behavior or the misconduct found on the part of Officer Deutschman by the town was significantly more than what was found on the part of the commission.
I guess I really didn't read it that way. Maybe
Well,
a couple of these so-called charges fell out, but the essence of what occurred, I thought, was pretty much the same.
Well, I believe that if you look at the record, it indicates that, for example, on the issue of excessive force, the town was relying upon testimony by the complaining witness that Officer Deutschman.
Yeah, but instead of going fact by fact, if you just take essentially what both agencies found, he engaged in conduct unbecoming an officer, and he violated the procedures of the Falmouth Police Department.
Yes.
Okay, so the essence was the same. I mean, you can pick apart little facts. So why, if the essence of the misbehavior, if you will, or the behavior, is approximately the same, why is such a change in penalty warranted?
It is clear that it is within the commission's discretion to modify a penalty.
Yes, nobody doubts that, but essentially where you have some terrific disagreement as to what happened, or, I mean, they look at that de novo, but, as Justice Cowan said, essentially nobody's disputing what happened here.
Oh, there is a serious dispute.
Yes, the points by points are disputed as with any fact case before a jury, any case. The little points are going to be different.
Was there a single push, or was there choking and slamming him against the car and bashing him into a tree? And they found one instance of force.
Exactly.
The town found like 5 different
Exactly.
ones. Okay.
Furthermore, the town...
But if he engaged in one, that is something that a person in his position shouldn't do. It violated policy to go out ab initio and respond to this complaint. So everything after that, it seems, is almost not totally irrelevant, but he was off on a frolic from the very beginning.
But, Your Honor,
And may I ask this? Couldn't the town have factored in that this was not his first infraction, but I think it was his 4th time, wasn't it?
Absolutely, yes.
Yeah, couldn't
And
that be factored in?
They
too?
did factor that in, and we believe that the commission also factored that in. When you look at the fact that the commission found, okay, he should not have put his hand to force the complaining witness back, that he used more force than necessary. When they found that he did not violate any type of an arrest rule, that he was completely justified in his inquiry. All of these things are things that the town
My
found.
But he
point
was
is-
justified. How can he be justified in his inquiry when he shouldn't have been there to begin with?
Officer Deutschman was not charged with violating any rule saying that he should not have been there. That was not what the findings of the town were. The findings of the
There's
town
a policy of the department that he's not supposed to respond when it involves a family member.
He was not charged with that. His discipline, his 180-day disciplinary sanction, was not based upon any finding that he should not have responded to that. The findings of the town were that he used excessive force, that his conduct unbecoming was based upon his use of that force, his failure to call into the police department when he put the young man in the car and backed up 100 or 150 feet, that he should have called in, that he didn't file a report. These are the things
And it
that
was
he
his 4th time. fourth infraction.
And I believe that the commission took that into consideration, given the fact that they found minimal behavior violations in comparison with the town, but still gave him a substantial suspension of 60 days. Therefore, I believe that the commission did take into consideration his prior record of discipline and did impose sort of a they increased what would have
Was there
naturally
evidence before that at the town hearing about his violating the fact that he shouldn't have responded to a family member?
No, there was not evidence saying that he violated this policy.
No. Was there evidence that he was responding to a family member?
Yes, there was.
And so when the town says that the appellate exhibited the prohibitive conduct as the entire sequence of actions illustrated in template conduct bringing, why can that not be included within that? I mean, his intemperate conduct, he gets a call from his wife, he goes, he drives down. I mean, they didn't charge him with driving down the road the wrong way as he goes searching. I'm looking now at the commission's decision, but he goes charging down the wrong way, and then stops in front of these three young people. I mean, there's not a particular complaint that he violated the traffic laws, but can't that be included in the catch-all thing of the town?
But my question then is why did they include particulars such as transporting him down this dirt road? Why did they include specifics such as taking him and placing him into the cruiser? If there's a policy that says you are not to respond to any situation involving your family, well, then it seems like that would have been the first thing that they would have charged him with. But they didn't. They didn't find a violation of that. They found a violation of false arrest, and to say that this catch-all phrase of conduct.
But I'm looking at the commission's decision. The commission seems, on page 98, it seems to be saying, that the town's procedures. It is well understood that a police officer does not respond to such a matter. So it's not as if the commission didn't take that into account.
Well, I think the fact that the commission did take that into account also.
But you can't have it both ways. You can't say, well, that wasn't in consideration and therefore it was lower, when the commission did take it into account.
But isn't that saying that the commission substituted its judgment and found something other than, or disciplined him on something other than what the town of Falmouth disciplined him on?
No, because I'm suggesting that the town of Falmouth had that as part of what was unbecoming.
But it seems that the town of Falmouth should have included that in their violations against Officer Deutschman when imposing the 180-day sentence, and it's our position that they did not.
Thank you, Ms. McClavey.
Thank you, Your Honors.
Mr. Norris? Yes, Mr. Norris.
Thank you. Good morning. May it please the Court. My name is Tim Norris, and I represent the town of Falmouth.
I don't know if you know this, Mr. Norris, but was the rule in question rescinded by the Civil Service Commission before or after the Mass Appeals Court decision in this case?
I believe it was rescinded before the Mass Appeals Court decision in this case.
Then, could you also clarify on that same point, didn't the commission then just adopt the standard regs,
That's
which
correct.
also include the mailbox rule?
That's correct. The
Okay,
commission.
so they substituted their own individual mailbox rule for the generic mailbox rule that applies to other agencies.
The other way around, exactly. They adopted the standard adjudicatory rules in place of the previous rules, which were their own rules. And the standard adjudicatory rules also, contain the same requirement, proof of a postmark. And in fact, to get more specific, they say that it can't be a postmark from a postage meter, but it has to be a mark from the U.S. mail, which is how I interpret the postmark rule in this case.
But there was no evidence of a postmark, as has been
There was
said.
no evidence of a postmark, and the town absolutely did not concede that issue at any level. We argued it to the Superior Court, we argued it to the Appeals Court, and we've argued it in our briefs to this Court.
And I take it part of your argument on this rule is that the rule certainly is applicable to filings in the course of a proceeding, but not to the jurisdictional rule that something needs to be appealed in writing within 10 days.
That's correct, Your Honor. The statutory authorization for this rule is found in MGL Chapter 31, Section 2A, and what it says is that the commission can make rules to govern the conduct of its proceedings. And we read that to mean proceedings over which the commission has lawfully obtained jurisdiction, not that they can make rules in aid of their own jurisdiction. We don't believe that rule was ever intended to be read that way.
But when you're dealing with something that says you must appeal in writing, it doesn't even use the word file, deliver, you must appeal in writing. Can't they set rules about what that means? Maybe it means, 2 copies. Maybe it means, signatures, or they can have, here's the thing that the writing must contain. Here's, they can set what that means, can't they?
Well, they can set it. They can set it with perhaps within some boundaries. When the next sentence after appeal in writing refers to filing and such filing, and making it clear that the appeal in writing is intended to be a filing, then we have to talk about we have to equate appeal with filing based on the way the statute is written.
If we agree with you, is that going to knock out the mailbox rule that's in apparently the standard adjudicatory proceedings, where I'm sure the same statutes will, here and there in certain contexts, use the word file or filing or receipt or who knows what?
I don't think so. I think that those rules, the standard adjudicatory rules as well as the prior rules in this case, are intended to govern the filing of myriad papers that get filed before these agencies. In the Civil Service Commission, you can have various motions, you can have requests for discovery, pretrial memoranda, or joint status conference memoranda. So all of those things have filing deadlines, and filing, the commission has seen fit to make filing of those documents, the date of filing the same as the postmark. It's not going to get rid of the rule. The rule serves a valuable purpose. I don't think the rule was ever intended to apply to these kinds of cases. There are a number of cases from this court. Most of them are tax abatement cases, frankly, but a couple of them involve various aspects of the civil service practice that basically say what we're saying in this case, which is filing is not the same as mailing, and if you're going to have mailing as a reasonable or an acceptable means of commencing an action, obtaining jurisdiction in one of these statutorily created boards, then the statute has to say that mailing is what will allow someone.
And if we agree with you on that, that's the end of the whole case.
That's correct, just as the appeals court did not continue.
And do you agree with your brother that if we arrive at that conclusion, we should make it prospective?
I do not agree.
No?
I do not agree with that. The cases that talk about, and first of all, prospective is an exception. The general rule is that cases have retroactive application. The test is whether, is there a big unforeshadowed event. I think what the Commission and Officer Deutschman would like to say is that this is going to cause the invalidation of regulation, and we don't agree with that. We don't think that the regulation needs to be invalidated because it can be construed in harmony with the law.
But one of its important applications, on which apparently numerous people dealing with numerous agencies have relied, is the belief that it also applies to the initial commencement of their administrative appeal.
Well, Your Honor, I disagree that certainly before the Civil Service Commission, I disagree that many people have relied on that other than in this case. There are no reported cases before the Commission before this one where the Commission accepted jurisdiction based upon the mailbox rule.
Maybe because nobody else challenged it.
Well, it may be, in fact, that the letter arrived within time. See, the concern that I have here is that the then applicable Civil Service Commission rule and the now corresponding, CMR talks about filing, time of filing, and filing is complete upon whatever it is. Fine. And the statute talks about filing. But the piece that we're looking at is appeal in writing. That doesn't say is filed within it's appeal in writing. I literally don't know what that means. It could be anything. It could be actual receipt. In other words, if I'm just out there and I look at, if I have access to the Massachusetts Civil Service Commission Rules of Practice 1981, timely filing, it doesn't tell me that that's what triggers GLC 3141. I mean, it just says appeal in writing to the commission within 10 days of receipt of the notice.
Right. But the next sentence speaks of that appeal in terms of filing. And, the cases before this court, INL,
The next sentence of what?
I'm sorry?
The next sentence of the statute.
The next sentence of the statute.
Right.
Refers to that appeal as a filing. So it's fairly inferable from just a plain reading of the statute that appeal is the same as filing.
Well, it still remains to me, I must say, I think a little bit ambiguous what appeal in writing would mean. If you're looking at the statute alone, not the regs, the statute alone, it seems ambiguous what appeal in writing means. And given that the enabling statute allows the Commission to adopt such rules of procedure as necessary for the conduct of its proceedings, does give them the authority to remove whatever ambiguity there might be in the term of appeals in writing. I mean, isn't the mailbox rule, even in the federal rules, part of their rules of civil procedure?
The mailbox rule finds itself in a lot of different places, but
including things that are called rules of procedure.
That's correct.
All right.
But isn't the word conduct of proceedings, the word conduct, important? Because that seems to import the notion that they can have rules once they get jurisdiction. That's the conduct of the proceeding.
That's correct, Your Honor.
And whereas this rule creates jurisdiction where the statute arguably means it shouldn't be there.
That's exactly right. The statute appears to equate filing with appeal in writing, and then the statute that gives the ability to create these rules refers to the conduct of its proceedings, meaning proceedings that
once jurisdiction is
already there.
Can I move to the substance here? Explain to me why it is that you say that the Commission acted improperly in reducing the penalty here. They had a whole de novo hearing. They heard from everybody. Isn't that what they're supposed to do?
That's what they're supposed to do. But what they found was a course of conduct that was largely the same as that charged, which is that Officer Deutschman.
Well, largely, but with some variations in terms of severity.
Yeah. I mean, and I assume, for example, if this officer had beaten this young man to a pulp, it would have still been called excessive force. The town finds, say, he beats him to a pulp, therefore there was excessive force. De novo hearing before the Commission finds he pushed him back once, still excessive force. Are you suggesting that they have to hand out, that those difference in facts wouldn't logically affect the gravity of the sanction?
Well, I think that the Commission should be concerned with what the appointing authority actually finds as facts and what the appointing authority heard and found, because if the Commission isn't concerned with the findings of the appointing authority, then how can it make the comparison between its own findings and that of the appointing authority?
Well,
but in this case,
but it's de novo. It's de novo.
Well, it's de novo on the findings of fact, and we haven't quarreled with the Commission's findings of fact.
Well, as I just look at I'm trying to find out why the Commission imposed the sentence that it did, okay? And it has a whole bunch of facts, and then it gives me the law saying that it can modify. Then in about, 12 lines, if that, it agrees with you that he exhibited conduct unbecoming an officer, that his state of mind was such that he used more force, takes into consideration that this was an incident at home. I take that to mean he violated the department's policy. He was responding to that incident, took into account that he had not arrested, right? And that's after their whole Terry stop analysis. And therefore, he did not transport a prisoner. It seemed to me that that was the one place that there was any divergence. because they find that the appellant didn't violate the department's rules of proceeding regarding arrest or transportation. And then they took into account that he's been suspended on 3 prior occasions, essentially for similar conduct, namely a police officer out of control. Mm-hmm. So, to me, it says, if technically he wasn't involved in an arrest, is that sufficient to reduce it? And what's your answer to that? Because everything else, they're minor details, but...
Well, our answer is no, it's not sufficient, and the reason is that, what we're looking at, the appointing authorities aren't judges and attorneys. They're looking at the conduct. What's the course of conduct? Whether it technically violates this rule or that rule. The bottom line is, he took this boy, he did use excessive force, he put him in the vehicle, he moved the vehicle, he never called it in, he never wrote a report, he never did any of the things that police officers do when they're doing things for a valid police purpose. He was on a private enforcement action. That was the conduct unbecoming, was that he took it upon himself to go on a private enforcement action against this boy and his friends. So that's the conduct that resulted in the 180-day suspension. I agree with you. If he'd beat this boy to a pulp, he would have been fired and probably criminally charged on top of it. But because it wasn't, because there was an injury which was found by the commission and by the town to the boy's back from falling against the tree. But the boy wasn't seriously injured, so on balance, the commission did the appointing authority did what it's supposed to do. It weighed its policy considerations for, not wanting to have out of control officers on private enforcement actions, and the past history of this officer, 23 disciplinary infractions, including 3 prior suspensions. Took a look at all that, all of the aggravating and mitigating factors, and came up with a determination that best matched the town's policies, what the town's policy goals were in relation to this type of conduct.
There's not that much of a disparity between what the commission found and what the town found. They both came to the conclusion that he had engaged in the use of excessive force, in conduct unbecoming an officer, and so forth. They're quibbling over a concept of law, namely whether there was an arrest or not. But that's not really the issue, is it? If the conduct that's found by both is, more or less equal in terms of a violation, they're supposed to defer to the town.
Well, it was a private enforcement action.
Right.
Violating a ton of rules along the way, including traffic rules and all kinds of things.
Excessive force, so on.
And, the idea that the town should have charged this or should have charged that, if the town made any mistake, it was charging this, too multipliciously so that the invalidation of the arrest charge. The commission said he was seized, the commission said he was placed in the car and moved. So however you want to parse that in terms of arrest or not arrest, it doesn't really matter. What matters is that was the conduct.
Well, so what then does the commission do? It's got the power to modify sanctions. It's got the power to hold de novo hearings, make its own findings of fact. So what are they supposed to do with all that?
Well,
it's not exactly what they did here.
The commission never allowed into evidence the findings of the appointing authority. So
I don't really understand that at all, but you make that point. I don't understand why they wouldn't.
I take it that one of the things that the commission is charged with doing is to make sure that somebody's fairly treated. In a small town, there may be access to grind, there may be politics, there may be somebody standing on ceremony to try and make a point, there can be all kinds of things. But other than that...
Once the commission finds basically the same conduct that the town found, the commission is obligated, is it not, to defer to the town's penalty?
I believe so, Your Honor.
The power to modify disappears at that point.
I believe that's a correct statement of the law, or what the law should be. Most of the law is from the appeals court, but there's a prior Town of Falmouth case and the Boston v. Collins case. And basically it says if there's no evidence of bias or political considerations, then the commission owes deference to the appointing authority.
Thank you, Mr. Norris.
Thank you, Your Honor.
All right.